file bankruptcy. Do I have to continue to pay my mortgage, or do I have to continue to pay the HOA dues? Well, we talked a little bit about the mortgage. I can't stand up here and say, don't pay your mortgage. I can't do that ethically. What I can tell you is that most folks decide not to do it. HOAs is a different story. All right, let's walk through this because this happens way too often. I'll tell my clients, the legislature has done what it did, and you have an obligation to pay your HOA debts after you file. It makes sense though, because if you have a tremendous number of bankruptcies and there's no obligation to pay those HOA dues, HOAs are going to have some problems running their communities. So there's an obligation to pay. And if you don't pay, guess who's probably going to get sued? Yeah, I've had 2 clients now where I told them, listen guys, pay your HOA dues. Or at a minimum, take that money and put it into a bucket. So if they do kind of go after you, at least you have that bucket, all right? Both of them didn't pay, and both of them didn't create the bucket, all right? So they called me a year later. I'm sued by my HOA, those jerks. Can't believe it, I paid for years. Well, okay, I told you. And then we have to kind of work out those issues, all right? So, however, let's just say you haven't paid your HOA dues for a year. What happens to that debt if you file bankruptcy? It all goes away, all right? It all goes away. However, if the HOA was smart and they filed a lien on your home, that attaches to your property. And an HOA lien is just like you borrowed money from Wells Fargo. It's a secured lien. It's not going to go away. And some aggressive HOAs, what they'll do, probably they're right for doing this, is they'll file bankruptcy. They'll say, great, you have no legal obligation to pay this debt. Bill, your client has no legal obligation, but we have a lien on their property for $10,000, and we're going to foreclose on that unless you pay us $10,000. And I'll tell my client, they got a lien. Well, I thought that we didn't have to pay because it's prior HOA debt. I said, yeah, it's true. You have no legal obligation to pay that debt. You can just walk away from your property, provided you keep making your current HOA payments, and you have to pay that debt. However, you're going to lose your property because they can foreclose. And most HOAs are savvy enough to know that homeowners will probably pay that $10,000 as opposed to losing their home. So they'll get into these payment plans, and almost without exception, clients pay that lien off over time. It just happens.
Doesn't the BK prevent them from exercising the foreclosure?
Good question. So 2 things happen. They can get the relief from automatic stay, lift up that wall. All right?
Qualify to get that relief?
They are. Okay. Secured creditors are qualified to get that relief. Secured creditors. What happens most of the time, though, is that after that 4-month period, they will, because it's expensive to file those motions with the court. So after that 4-month period, then they'll start the foreclosure proceedings. What really happens is that during the bankruptcy period, they'll call me and they'll threaten me. Well, we're going to foreclose. We're just going to wait. And we enter into some type of an agreement. And basically, it's payment over 1 or 2 years. Because what really kind of happens, if you think about it, it's interesting. The HOA is going to foreclose. Right? Land owns a condo. This didn't happen to you, I'm just making an example. Land owns a condo. Didn't pay his HOA dues. Former president of OCAR. All right? So did not happen. So he didn't pay his HOA dues, and they foreclosed. What that really means is the HOA now can take possession of his property. However, they're down here. There might be a first and a second, so they buy it. They get it subject to the second, subject to the first. They have to pay those. Well, HOAs do different things. HOAs may sell it. They may put a renter in there and not pay the first and the second. I've heard that happening a lot as well. So there's different ways HOAs work it out, but practically speaking, HOAs typically get their money because people would rather pay that amount as opposed to actually having to leave. And they're not paying mortgages most of the time, so it's kind of takes the place of the mortgage.
I know a couple instances where the HOAs did bring a foreclosure, and they got wiped out as a junior lien.
Yeah.
But they said, what they wanted to do was set an example to the other residents that they're willing to do that.
So they had a foreclosure, but they're wiped out earlier?
Well, they foreclosed,
Yeah, we're the
and
true
then they got wiped out by the more senior liens.
Yes.
They didn't get any money.
Mm-hmm.
But
Oh, yeah.
they set an example to the other residents who were thinking about it, that they're willing to do that.
Yeah. The other, it's real as you probably know, it's driven somewhat by the board of directors and how aggressive they want to be on the HOA and all that stuff. Yes?
If there's a situation that HOA can sue the homeowner, even if it's being foreclosed. My client who refused to do a short sale got foreclosed by Wells Fargo 2 years ago, and now he received a summons for $11,900, where in 2 years ago, he only owes $2,300. So the association attorney waited until the amount goes larger so they can file
Just darn
a
attorneys.
lawsuit against this little guy.
Yeah, remember though, it's a good,
It's not attached to the property. It's a lien against him. That's what
yeah.
they said.
Did your client file bankruptcy?
No.
Yeah.
He didn't do anything.
Yeah, so remember that, it's a good point, because really the obligation to pay HOA dues typically is on the person who is on title. And if you're not going to pay that, and let's say you have a short sale, you have a short sale and the HOA doesn't get a penny, all right? That HOA can still go after the homeowner. Happens, well, happens, no, I'm sure it happens, well, it can happen, it's happened all the time, I don't know if it happens all the time, but it happens, because it's an obligation. That's why when we do short sales, which, if I'm working with a client on a short sale, or a real estate agent, I'll say, listen, what you need to try to do is get some type of waiver where the lender cannot sue the homeowner. That's the best thing you can do. If you can get that, that's what you need to do.
Is there a statute of limitations on that?
Through a statute of limitations. So the question is there a statute of limitations in which a bank can go after or sue a homeowner? Yes. For breach of a promissory note, which is what notes are, it's a 6-year statute of limitations. But the issue is, when does that 6 years start? When is it, when is the triggering date? And so then that's, in some of the legal actions we're involved in, one of the issues might be, well, when did the statute start? Does it start here, start earlier in time? Typically, it starts at the time of the breach, i.e. when you stop making your payments. Yeah, typically that's how it starts, typically. But 6 years, so, yes.
If your client is doing a short sale, the association gets paid by, somehow it gets resolved before you close the escrow. So why would that happen?
Oh, mine was foreclosed.
Oh, foreclosed.
Yeah, a short sale, yeah, because you have to pay off all the liens through
Yeah,
escrow. This
generally
was
the buyer
foreclosed.
pays for that association.
Yeah, well,
Just because they don't have an option, they either take the house with the HOA or walk from the
Yeah, no,
house.
the lender would not allow the association fee to be dangling there. Not the buyer's lender would not allow that. It has to be paid off.
Oh,
in
right.
the escrow
Yeah,
time.
short sale, yes, short sale, yes.
yeah, well, I'll answer, there's actually some good issues. One, you can buy the property subject to the lien. So if $10,000 HOA lien, the HOA is on budget, you buy it, but you got the lien there, you inherit it.
Right.
Your situation is, I can deal with your situation. If you have first, second, and HOA, and you have an HOA lien, if the first forecloses and the second and the HOA are wiped out, what that really means is that property is not encumbered. It doesn't have that stuff. The person who owns it still has the obligation to pay it. It's just it's not encumbering the property. It's an important distinction, but it's a distinction. And remind me what your question was. I have to make sure we're on the same page.
Well, no, I was just saying that if it's short sale, not foreclosed, generally the association that's unpaid, it gets paid by the buyer with the negotiation of
Correct.
Through the HUD or whatever, they will get the buyer to pay for that association.
Yeah, it's a good issue.
That's what I've been doing.
Because let's just say let's say you're owed $5,000. The HOA is owed $10,000, and the HOA agrees to take $5,000.
Yeah, negotiated unpaid.
Typically, the HOA will not go after the owner, but they can if they want to. Remember, a short sale is just you're agreeing to release the lien for a certain amount of money. And it doesn't necessarily mean, though, that the HOA is giving up the right or the obligation to go after the homeowner. And that's where you guys got to be really careful about how you communicate to your clients, because regularly people will call me, I'm going to sue my agent. Why is that? They told me blah, blah, blah. All right? And, you know, I have no idea what really happened. But you have to be careful about that, because ultimately, if you deal with short sales, what you say, what you don't say, really can come back to bite you in that sense. So it's all about adjusting expectations. Yes?
As realtors, we're not allowed to discuss legal issues.
I know.
Or finance. Financial issues, you stick to just the real estate thing, and you refer them
Yeah.
to the Roberts.
That's true, but the reality is those issues those lines are blurry at times, and I recognize that, because for the most part, you guys know, and you know the right answers because you do it a lot, but at the same time, there might be things you don't know, or there's things that you say that a client has a different recollection of what you said, although you know what you said, just because people are people.
Right.
Yeah, emails and writing is a great thing.
So many times I try to convince my clients to short sell their house even though they filed a bankruptcy and they're going to, and they don't see why, because their credit is already ruined with PK. So I'm just looking for some ideas.
Sure. How, in that situation, what do they intend to do with the home? Let it go to foreclosure?
Yeah.
Do that, okay.
Just wait, because the BK extends the time they can stay in the house.
Exactly.
So they'll just let it go to foreclosure,
Yeah.
not worry about having traffic
It's
to
a
their
good
house.
question. So this is the issue. Oh, yeah.
If you could repeat the question.
Oh, sure, yeah. So the question is, somebody files bankruptcy, and mentally they're saying to themselves, I'm just gonna let the home go. I'm just gonna let it go to foreclosure. I just don't care. Versus, I'm going to try to sell this home through a short sale. I have no legal obligation to pay the debt, but I'm going to take the time, take the effort, work with an agent, hire an agent, and go through that process. What's the better route to go? I always encourage clients to do the short sale route for two reasons. One, it looks a heck of a lot better on the credit report. Short sale versus foreclosure, right? Foreclosure is a major, major ding. So that's number one. Number two, it's a controlled process. If you want to stay in your home for a while and leave in a way in which you can kind of control the timeline to some degree, short sale is the way to go. Foreclosure, what's going to happen, and it has happened, home goes in foreclosure, and the next step is that the client gets a notice, a 3-day notice. Get out of my home. I own it now. They call me, oh my gosh. And what am I going to do? I said, well, this is going to happen. Next step is they get something called an unlawful detainer legal action, which they're being sued as a defendant, saying you got to get out of my house. All right. So that's kind of the mess, you know. And then there's an issue as to whether the legal fees and whatnot are part of the bankruptcy or not the bankruptcy, and there's different practitioners have different perspectives on that. And if you want to be embroiled in litigation and unpredictability, then go foreclosure. If you want a controlled process that is better on your credit report, go short sale. So that's my 2 cents on that. So, but good question.